my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. Today we're going to talk about what you do when you receive a divorce summons. Now let's bear in mind what part of the process you're in once that occurs. In order for you to have gotten a summons, certain things have had to happen already. Number one, somebody went and hired a lawyer. That lawyer drafted a summons and a complaint for divorce, and it was filed with the court clerk. The court clerk then would have randomly assigned it to a family court judge, and that judge issues a summons. A summons is an order to take action, and essentially that summons attached to that complaint will then get sent back to the originating lawyer, and that lawyer will arrange to serve those papers upon you. The service can be conducted by a bailiff or a court officer or really any functionary other than the party themselves, and now they've been presented to you. What should you do? A lot of people, for some weird reason, I think maybe just defensively or without really thinking, the knee-jerk reaction is to evade service. We all have those images of the process server trying to chase somebody, the guy running out the back door of the house or something like that, so he's not served. It's really ridiculous in those cases to do that. What should be done is that you should take the papers, because you're going to need to advise your lawyer that you got them. You're going to need to read them. You're going to need to figure out what they say and what, if anything, you should do about them. And of course, with that, in conjunction with your lawyer, you can devise a strategy of how to handle those divorce papers. Now, if you do what other people do, what other people talk about, what other people think about, and you evade the service, then here's what happens. You don't know what the papers say. You don't know how to develop a strategy to defend them because you don't know what they say. Your lawyer is completely out of the loop, and the process continues anyway. They'll try a couple times. They'll send another bailiff. They'll send a bailiff, the same bailiff, but maybe 2 or 3 times. Eventually, that bailiff will write an affidavit of service, and he'll tell the court, you know what? I know the guy's there. I identified him. He won't come to the door. He runs away from me. He throws things at me. He won't accept service, and all the court will do is authorize substituted service. And substituted service means they won't hand it to you, so you won't get the benefit of it. They'll tack it somewhere or post it somewhere. And then you know what's likely to happen? You're not going to see it. And if you don't see it, you don't know what it says, and you can't get it to a lawyer, and you can't defend it, and all what will happen is eventually a default will enter against you. And then you won't be able to weigh in on what happens in your case without specific permission of the court that allows you to do so. So that's not the way to do it. When you get the summons and complaint, it's coming your way, take it, read it, get it to your lawyer, and sit down and devise an appropriate defense strategy that will see you through your divorce case. Now, if you have any questions about that, reach out. We'll be glad to help you out.